pandemic and the judicial response. I would like to first thank Professor Dr. N.S. Santosh Kumar, Honorable Vice Chancellor of Tamil Nadu Ambedkar Law University, for providing us with this wonderful opportunity. Now, I call upon the person who put in all their time and efforts in putting together today's event for all of us. I welcome Professor Dr. Kumudaratna, Director, Postgraduate Course, Head of the Department of Business Law, School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University, to give the welcome address. Over to you, ma'am.
Thank you, Nivedita. A very delightfully wonderful morning to one and all present here, and also to those who will be joining us in due course of time. I deem it a privilege bestowed upon me to deliver the welcome address in this webinar. A grand welcome to our chief guest, Dr. ASHWANI Kumar sir, for accepting our invitation. Sir, thank you very much for accepting our invitation, taking the time and making the effort for delivering the keynote address in this our webinar. We are very grateful to you, sir. Thank you very much. My respectful welcome to Professor Dr. N.S. Santosh Kumar sir, the Honorable Vice Chancellor of this institution, the Tamil Nadu Dr. Ambedkar Law University. Sir, thank you very much for the impetus and the spark you have put in us for conducting a series of webinars and for enabling us, for equipping us in conducting the webinars in a very systematic manner. Thank you very much, sir. A courteous welcome to Professor Dr. C. Chokkalingam, sir, for accepting our invitation and coming to this webinar. Professor Dr. Chokkalingam, sir, is the Director of Legal Studies of this institution, the state of Tamil Nadu. Thank you very much, sir, for accepting our invitation and blessing this webinar by your gracious presence. And moving on, I know there are a number of dignitaries present in this webinar at this point of time, but because it is a virtual meeting, we are unable to, identify each one of you. A very special welcome to all the dignitaries present here at this moment. We thank you very much. A thankful welcome to each and every one of the dignitaries. Thank you, sirs and ma'ams, for gracing this occasion. And also, my appreciative welcome to each and every one of the principals of the various government colleges affiliated to this institution. Some of them are already here. I would like to name and welcome them. Professor Dr. Gauri Ramesh, a principal of the Pudupakkam Government Law College, Chennai. Madam is also a syndicate member of this institution. A welcome to Professor Dr. Jaya Gauri, principal of the Government Law College, Madurai. Madam is also a syndicate member of this institution. Welcome, ma'am. A welcome to Professor Dr. Vijayalakshmi Ramalingam, Principal of the Government Law College, Chengalpet. Welcome, Madam. And also a welcome to Professor Dr. Durga Lakshmi, Principal of the Government Law College, Salem. And I also welcome various other principals who are in the process of logging into this webinar. Welcome each and every one of you. A cordial welcome to Professor Dr. Balaji, who is the registrar of the Tamil Nadu Dr. Ambedkar Law University, and also he is the director of the undergraduate courses of the School of Excellence in Law. Welcome, sir. A hearty welcome to the Controller of Examinations, Dr. Srinivasan R. And also a welcome to Professor Dr. Harita Devi, who is the Director of the Research, Publications and Academic Affairs of this institution. A welcome to Dr. Ashok Kumar, who is heading the library wing of this institution, one of the premier libraries in the state of Tamil Nadu itself. A hearty welcome to you also, sir. And also a happy welcome to the heads of the 10 departments of the School of Excellence in Law of Tindalu, namely Dr. Reddivari Revati, Dr. Lucky George, Dr. D. Bhuvaneshwari, and again, Dr. Harita Devi, Dr. S. Rajalakshmi, Dr. S. Elumalai, and Dr. J. Mahalakshmi, and finally, Dr. Balamurugan Panichami. Welcome to each one of you. A very warm welcome to each and every one of the teaching faculty members of the School of Excellence in Law and also of the affiliated law colleges to this institution, many of whom are products of the School of Excellence in Law, having studied here and also presently doing PhD also here. A very hearty welcome to each and every one of you. A very gracious welcome to each and every one of the administrative staff of this institution and also the technical team. Especially my welcome to Mr. Darwin, who every time creates the WebEx links and also takes care of the YouTube link. Thank you, Mr. Darwin, for being responsible for the smooth functioning of the WebEx and also the YouTube link today also. And also, finally, with all my heart, a very enthusiastic welcome to each and every one of the bright minds that are here, burgeoning lawyers present here in the form of student community, student fraternity, and they comprise of undergraduate course and the postgraduate course of the School of Excellence in Law, and also of the almost 16 government law colleges affiliated to this institution, and also the students from various educational institutions who have registered and who are present here also. Today morning, we were checking the registration list. We found that many of the students have registered from the northern states also. A very hearty welcome to each and every one of you, my dear students. And also, once the keynote address is over, I hope you take part in the brainstorming session in the form of asking pertinent questions to our chief guest, sir. A gracious welcome to each and one of you present here. And also, I would like to thank every one of you for making the time and making the effort of being present here in our webinar, making it a grand success. Thank you, one and all. Over to Professor Dr. Balaji sir for delivering the felicitation address. Welcome, Dr. Balaji sir.
Yeah, thank you. Thank you for that. Yeah, am I audible?
Yes, you are.
Yeah, thank you. Good morning to all and all. Now, at the outset, let me congratulate and wish the success of the online national webinar on the pandemic and judicial response organized by the Department of Business Law of the Tamil Nadu Dr. Ambedkar Law University today, on 10th June. I am to say that the topic chosen was very, very apt and relevant at this point of time and to the situation. I'm happy to be amongst the distinguished speaker who is as our chief guest, Dr. ASHWANI KUMAR, the Senior Advocate of Supreme Court of India, Honorable Professor Dr. N.S. Santosh Kumar sir, Honorable Vice Chancellor, my esteemed colleague Dr. Kumudaratna, HOD of Business Law, and Dr. Haritha Devi, HOD of Department of Environmental Law, and my colleague Dr. Ranjit Abraham, Assistant Professor, who is also from the Department of Business Law. Now today we have our distinguished speaker, who is none other than Dr. ASHWANI KUMAR, a senior advocate of Supreme Court of India. When I was going through his profile, it was very rich and it was very great, and such a personality is being with us today to deliver his keynote address. Now he has adorned many flourishing posts such as Union Minister of Law and Justice, Additional Solicitor of General of India, and very particularly as the Envoy of Prime Minister to Japan, etc. Being simple and most humble, Dr. ASHWANI KUMAR is an eminent lawyer, thinker, author, and a veteran parliamentarian. Was a member of the Rajya Sabha for 14 consecutive years, till the end of his tenure in April 2016. Not only that, he was appointed as the chairman of Parliamentary Standing Committee on Science, Technology, Environment and Forests between the years 2015 and 16. And he was also served as chairman of the Select Committee of the Rajya Sabha for the Prevention of the Torture Bill 2010. Dr. ASHWANI KUMAR has represented India in the highest forum of diplomacy, including the United Nations General Assembly, the United Nations Security Council, and also at the World Economic Forum. It is very pertinent to note that Dr. ASHWANI KUMAR is also a crusader for human rights and has taken up several causes, including the enactment of comprehensive anti-custodial torture legislation for India, and also the issue of right of the elderly to live with dignity, and a very sensitive issue on the human rights of Rohingyas. He has espoused the cause of liberty of human rights activists, apart from appearing before Supreme Court to oppose prenatal sex deduction tests to prevent female feticide. Now I can say more about him because profile runs into pages and it has a very rich content and credentials. However, due to the paucity of time, I cannot able to deliver all its credentials, which is too lengthy. But however, we are once again very happy to have such a towering personality who's here with us today to give a keynote address. Sir, we are very grateful and delighted to you for giving your valuable consent to be part of this program and the great and to grace the occasion, sir. Next, we have to greet our Honorable Professor Dr. N. Santosh Kumar, sir, the Vice Chancellor of the University. Since he is suddenly in this post today, morning, he could not able to make it today, sir. However, he has sent a message greeting every one of us and very particularly to our chief guest, the distinguished speaker, Dr. ASHWANI Kumar, sir, and for the successful completion of the program. A few words about our Honorable Vice Chancellor, who is also so simple and humble in many ways, and who also took charge very recently. Of course, he is not a new face to our university because as in the capacity of the syndicate member, as the Director of Legal Studies earlier of a long stint, he supported in the development of this university at every stage of its growth. And not only that, as a stint as a Director of Legal Studies for more than 7 years, he has got a tremendous track record in the development of legal education in the state of Tamil Nadu. His contribution is exemplary in the formation of more government law colleges across the state of Tamil Nadu. A hardworking visionary who has now taken the mantle of the Tamil Nadu Dr. Ambedkar Law University. And from the day one, he is persistent throughout about the welfare of the university and the law students and the faculty members, and motivate the faculty members to achieve greater heights. He has also given a full freedom to all faculty members to conduct the academic related programs freely. Sir, we are really blessed you to have as our Vice Chancellor and always as a guiding force towards the success of every program of this university. Now next I have to greet the present Director of Legal Studies, Professor Chokkalingam, sir, who is once again was with us for all the programs on the growth of the university. So he has taken part as a syndicate member in every growth of this university, and now he has taken or adopting the post of the Directorate of Legal Studies. Once again, I greet him and also welcome him to this program. Next, my wishes goes to my esteemed colleague, Dr. Kumaratna, HOD of Business Law, who along with the Honorable Vice Chancellor has chosen this topic as well as bring in the distinguished speaker today. And Dr. Anita Devi, HOD Department of Environmental Law. And I also greet Dr. Ranjit Abraham, Assistant Professor of the Department of Business Law. And I don't want to dwell into the topic as it is well assigned to our distinguished speaker. As everybody, I am also eager to listen to him. So without taking much time, I am with these few words, I am greeting one and all for the success of this program. And I once again welcome you all and thank the organizers for giving me this wonderful opportunity. Thank you. Thank you so much. And now I welcome and I wish our distinguished speaker, the Chief Guest, Dr. ASHWANI Kumar, sir, to deliver his keynote address. Please, sir.
Thank you very much for your generous words of introduction. May I start by thanking the Honorable Vice Chancellor of the University, Dr. Santosh Kumar, Dr. Chokkalingam, Dr. Balaji, Dr. Kumatharatnam, and Dr. Harithi Devi, as also other eminent members of the faculty, distinguished guests, students, ladies and gentlemen. I'm indeed most grateful to the organizers for requesting me to be the keynote speaker this morning. This is a subject close to my heart. It is contextually relevant, and it is being conducted. This webinar is being conducted in the framework of a devastating humanitarian tragedy that has struck the world and our country. It is unprecedented in the scale of its devastation, unprecedented in terms of the human misery that it has caused across the world, and also a defining moment in the evolution of human society. The reason why we are here today to speak on this subject is that when all centers had ceased to hold, and when governments all across the world were grappling to find adequate means and ways to deal with this unprecedented human tragedy, we found recourse in the institutions of democratic governance to at least partially relieve the human distress that the pandemic had caused. And one of those institutions of democratic governance is the judiciary in all democracies. This subject is also extremely important for another reason. And the reason is that as we discuss the role of the judiciary, we cannot miss the fact that of late, the moral standing of the highest court had been dented on account of what many have seen as an abdication of an activist role in securing civil liberties and human rights. My thoughts go out certainly to the earlier part of the pandemic in 2020, when stranded migrants looked in vain to urgent relief by the Supreme Court. My thoughts also go to a colossal abdication of judicial duty when a young daughter and a political activist was not given bail by a high court in order to meet her father, possibly for the last time before he died. And he died without his daughter having been able to see him. I cannot also forget when one of the high courts failed to pass suitable instructions so that emergent oxygen supply was made available to a petitioner before it, who died while the court vacillated and expressed helplessness. I sincerely hope, as a devotee of the law and as an officer of the courts in which I have practiced all my life, that these are only temporary aberrations in the otherwise sterling record of our judiciary in the protection of human rights. As the nation was beginning to question the resilience of its institutional infrastructure, we found the high courts of the country, and indeed the highest court, the Supreme Court of India, proactively intervene in a variety of situations in order to bring relief and succor to the millions of Indians in distress. We have seen how the high courts across the country have intervened proactively in the exercise of the plenary constitutional jurisdiction to issue suitable directions for ensuring emergent oxygen supplies to gasping Indians, hospital beds to those who needed hospitalization, vaccines, essential drugs, and relief to the old, disabled, and destitutes, particularly those living without care or in old age homes without any family members or friends to provide moral and emotional support. In these testing times, our judiciary has risen to the occasion. And I'm proud of the fact that as a practicing lawyer, we are all part of that judicial system that has vindicated people's faith in our institutions of democracy, particularly judicial. The crowning judgment in recent days has been the one recently delivered by a bench presided over by Honorable Justice Chandrachud, whose compelling articulation of constitutional imperatives forced an otherwise reluctant government to change its vaccination policy in aid of the constitutional right to life and health, and thereby ensuring free vaccination to the vast multitude of Indians or vaccination at affordable prices. In its own words, the court resorted to what it termed and aptly described as a bounded deliberative approach, in which, through a dialogic process that ensured engagement between all stakeholders, a new paradigm of scrutiny of government policies was evolved. And it is to the credit of the government that it accepted the compelling rationale for a change in policy as expounded by the Supreme Court. Now we know that if at all there is any answer to the devastating misery caused by the pandemic in terms of loss of life and health of the millions of people across the world, it is vaccination. In ensuring a rational, fair, just, non-arbitrary, and enforceable policy of vaccination, procurement, and distribution, the Supreme Court has rendered it an extraordinary service to the people of India. And I'm sure this would become a model for other countries to emulate as well. One of the most remarkable features of this judgment, and I'm singling out this judgment for a longer comment, is that it is not only scholarly in its articulation, but it is driven by a sense of compassion and equity that, in my view, must always inform the decisions of the highest court. We know as a matter of jurisprudential concept that a nod by a judge in a case or a refusal of a nod by a judge in a particular case does more good or harm than any general enactment or legislation. We also know that it is through the judgments that law is discovered. It is through the pronouncements of courts that law finds meaning and purpose. And it is through judicial pronouncements that the law remains a living law. And we all know that we have accepted that the Constitution of India is a living document which must respond from time to time to the felt sensitivities of the nation. This judgment, I must say, and say with great deal of pride, is an outstanding example where judgment and justice have coalesced. Judgment of the court in any democracy has to be aligned with the felt sensitivities of the nation. I must say that our high courts and the Supreme Court, in its various decisions, has demonstrated beyond a shadow of doubt that judicial sensitivities and national sensitivities stand aligned in these defined times of the pandemic. I must also mention that the quality of governance in any democracy depends upon the resilience of its institutions that are established to serve the democratic ideals. Judiciary is one such institution in our country that, apart from being the final arbiter of constitutional conscience, is also the keeper of faith with the people of India when it concerns the national sentiment on a subject that touches each one of us closely and permanently. Throughout the course of the constitutional history of India, the judgments of the Supreme Court have reflected a willingness and resolve to meet the aspirations of India, of the Indian people, in consonance with the values of the Constitution. I would like to emphasize that it is only in the consolidation, expansion, and expounding of the values of the Republic that the judicial voice finds its relevance and strength. Having briefly expressed myself on how I view the role of judiciary in the pandemic, I would also like briefly to touch upon the issues that have arisen as we experiment with the exercise of power in a democracy that is dispersed between the three organs of the state. Very often, a question is raised about the rightful boundaries of judicial power in a democracy. This, as you all know, is a perennial debate and does not admit of easy answers. It is also a relevant debate which must inform all democracies and eventually will define how the sovereign power of the people is dispersed between the three organs of the state. But for the moment, suffice it to say that the Indian Supreme Court has shown the way, asserting, recognizing, and admitting that its authority rests in the moral integrity and the intellectual honesty of its judgments. It is on the touchstone of what the judgments do for and in furtherance of the Constitution and for the people of India that the judicial authority would be tested. And this is how it has been, and this is how it shall be. In conclusion, allow me to read a few points that I had jotted in order that the coherence of the presentation is preserved. My conclusions, therefore, are that despite missteps, judicial response in its entirety to the pandemic's many challenges must gladden our hearts. Constitutional courts have decisively leaned to uphold human rights, navigating as best as possible the complexities of the equilibrium of dispersed power to secure the Constitution's preambular promise of a just society. Consolidating further the Constitution's dignitarian philosophy, recently reiterated in such landmark judgments as Puttaswamy, Romila Thapar, Nambi Narayan, Navtej, Johar, Tehseen Poonawalla, etc., the Supreme Court has declared unequivocally that government policy dealing with the pandemic must be bound by the human rights framework. It has reaffirmed that there are limits to the limitations on human rights. Responding to the felt sensitivities of a nation in pain, the Supreme Court has refused to be hemmed in by arguments of institutional incapacity and the usual caution against entering the policy domain and interference with government's policy prescriptions. In negativing the argument, it has asserted the entrenched principle that constitutional institutions established to subserve national goals must pull together in a cooperative enterprise. Its recent rulings have affirmed that India's constitutional democracy has moved beyond the majoritarian premise and that the court's interventions are to recall Ronald Dworkin in the service of its most conscientious judgment about what democracy really means, indicating at the same time that it is not an usurping tyrant trying to cheat the public of its democratic power. In an unexceptionable assertion of its plenary jurisdiction as guardian of the Constitution, the court has reiterated that the purpose of judicial function is to hold government true to the constitutional standards of reasonableness. While delineating the boundaries of its authority, it has left none in doubt that in the event of a conflict between policy and principle, it is the latter that will prevail. And this, as the Supreme Court itself reminded us in its landmark judgment in V.G. Rao as early as 1952, is not out of any desire to tilt the legislative authority in a crusader spirit, but in discharge of a duty plainly laid down upon them by the Constitution. Considering the judicial role is contextually driven, our superior courts may legitimately see themselves as constructive participants in a vital national seminar in these exceptional times. And they must seek legitimacy for their decisions in the normative umbrella of the Republic's foundational values. However, the challenge of effective enforcement of judicial decisions remains. We know, as Justice Chandrachud reminded us in Romila Thapar, that lofty edicts are meaningless unless translated into rights. We must constantly remind ourselves that the power to declare law carries with it the duty to enforce it, and that our Constitution does not envisage courts to be silent spectators when constitutional rights of citizens are infringed upon by the executive policies. The defining challenges of our times demand that our constitutional courts discharge their mandate as custodians of the constitutional principle vigorously, secure in the belief that the moral integrity of their judgments will prevail over the impulses of transient majorities. Abnegation of judicial authority is not an option when defense of the Constitution, which is a sublime oration on human dignity, demands judicial intervention. For supremacy of the Constitution to remain the defining distinction of our democracy, the law must work itself pure through judicial pronouncements which give it form and meaning. The judicial branch of the Indian state, ladies and gentlemen, has its task cut out, even as the debate on the boundaries of judicial power in a democracy rages on. With these words, I would like to conclude my opening remarks and would be delighted to take such questions as any one of you may have. Thank you very much once again for asking me to be with you.
Thank you very much, sir. Now I invite Professor Dr. Ranjitoman Abraham to open the floor for question and answer session.
Good afternoon to all present here. It was a great webinar for us to hear and listen to our chief guest and keynote speaker who was very clearly spoken to us about the judicial response to COVID and also the role of judiciary in the present scenario. So if anyone has any questions, you can post it in the chat box and I'd be happy to read it out to our keynote speaker.
If anyone wants to voice the question, you can switch on your video, co-host, and you can unmute and voice your question too. Thank you.
Before the questions, so the first question is, so what's your opinion about the reliance on courts and judiciary, which means for addressing core moral predicaments, public policy questions, and political controversies?
This is from Dr. Rajalakshmi. She's a faculty of this institution heading the criminal law department. Thank you, sir.
Well, thank you, Dr. Rajalakshmi, for the question. This is a matter of perennial debate. What is the role of courts in addressing political questions, whether they should enter the political thicket or not, or whether at the end of the day, their role must be confined to adjudicating only individual disputes that are brought before it. Now, there are no easy answers. In fact, most of the current jurisprudence addresses itself on two sides of the same subject. But I would hasten to add that constitutional courts have a role much larger than as adjudicatory authorities for individual disputes. The Constitution is a political document. The issues that Constitution raises are issues that go to the root of our democracy, and therefore, to the extent that courts are interpreting a constitutional document, they cannot move away from the history of the country. They cannot move away from the vision for the future of the country, and they cannot move away from the present challenges which they must confront in the exercise of the constitutional jurisdiction. Therefore, when the court takes on public issues, which they have been doing in a large number of public interest litigation cases, I think they are not, in a way, transgressing the boundaries of their jurisdiction. They are expounding what they believe and what the Constitution itself commands them to do, what they believe are the parameters of the Constitution. And that is why, as one of the Supreme Court judges of the United States said, that to say that the decisions of the courts are essentially undemocratic because a few brethren in black robes cannot take over the democratic mandate of the people, the answer that the judge gave was that what the brethren in the black robes do, they do by the command of the Constitution itself, because it is the Constitution that makes the higher judiciary as the final arbiter of the constitutional scheme. So I think that it is necessary sometimes for the court to enter into questions that could be political essentially, but they do so by deciding them within the framework of the Constitution.
Thank you, sir. There's another question from Dr. Harita Devi, who's our Director, Research and Publication. The question is, how far our judiciary is able to keep up the right to health, especially the right to vaccination for all our citizens, because ultimately it is left to the government to execute?
Well, it is quite clear that the Supreme Court is not the executing branch of the Indian state. The executing branch of the Indian state is the government, elected by the people, and in a democracy, the power of execution of policies, as indeed also formulation of policies, must eventually rest with the government. But the government has shown wisdom in accepting what the Supreme Court of India has recently suggested to them. And therefore, I think the Supreme Court of India has played a very dominant and exemplary role in ensuring that the government reverts to its earlier policy of universal free vaccination, so that the promise of Article 21 is not denied to anyone. There is, of course, a small percentage of people who will have to pay what is now affordable for vaccination. But by and large, the court has ensured that the policy of the government is right. And yes, we do hope that the government will now execute and implement the vaccination policy by harnessing and marshalling the full resources of the Indian state in what is clearly the most dominant and paramount constitutional purpose at this point of time.
Thank you, sir. Thank you for that answer.
So there's another question by Dr. Revati, who's our Director IQAC and HOD of Constitutional Law Department. Her question is very simple. Is the Constitution working amid this pandemic scenario?
Yes, indeed, the Constitution is working. If the Constitution were not working, would we see so many humanitarian interventions on behalf of the Supreme Court and the various high courts? And also, if the Constitution were not working, would the government of the day be trying its best to secure the lives of the people of India? And I think the fact remains that this has got to be a cooperative endeavor. This cannot be a partisan or a political endeavor. This is a global challenge, a national challenge. And all institutions of the Indian state must converge in bringing relief. Their efforts must converge in bringing relief to the people of India.
Sir, I personally have a question, sir. Do you think that there's any need for any constitutional amendment in a pandemic scenario like this? Because you would have seen the working models of other countries' constitution. From your experience, we would like to know, is there any need for any specific constitutional amendment in our country?
We have the longest and a very comprehensive constitution compared to other constitutions in the world. I don't think there is any need for an amendment of the constitution. The principles of constitution, which have been reiterated by the Supreme Court in a variety of decisions over the years, clearly demonstrate that almost all possible challenges that the nation could face can be confronted within the framework of the Indian Constitution. And I'm sure that if at any point of time there is a need to amend the Constitution, the Parliament of India would certainly exercise its remit and do so, as we have done over the last several years. At this point of time, only to meet the challenges of the pandemic, which are basically challenges to the health and lives of the Indian people, we need nothing more than the expansive remit of Article 21. Article 21 ensures the right to life with dignity and right to life with health to all Indian citizens. And that is really the most important challenge today. And I think Article 21 in its expansive sweep is more than enough to take care of the legal framework necessary for the government to work within.
So there's a question from Deepa Christina, one of our students. She's asking what would be the most wonderful learning opportunity for the judiciary in this pandemic, especially in terms of challenges and the responses which the judiciary have initiated.
Well, I think all of us learn every day, and so do institutions of democratic governance, whether it is the judiciary or the executive or the legislature. I think there are many, many lessons that this pandemic must teach us. And I believe that it is our duty, our bounden duty, to respond to the challenges of the pandemic, and the most effective way is to learn from the shortcomings that we have noticed in the functioning of our democracy, in the functioning of our national medical infrastructure, in the inadequacies of our initial responses. And I don't blame anyone for the simple reason that this is an unprecedented situation. No nation in the world has been prepared for this kind of devastation and human misery and the challenges that it brings in its wake. The Indian state, within the limitations of its resources, has endeavored to do whatever it could, and the judiciary has lent a constructive lending hand in the process.
So there's another question from Shushma. She would like to know the problem between the doctrine of separation of powers in these scenario of pandemic.
Well, the separation of powers is an established part of our constitutional democracy. The sovereign power of the people within the constitutional scheme has been dispersed between the three organs of the Indian state: the legislature, the judiciary, and the executive. And all the three organs of the state are supposed to work within their respective spheres. Although the boundaries of that power, when in question, and the equilibrium of power when in question, is left finally to be determined by the Supreme Court as the interpreter and guardian and custodian of the constitutional principle. And that is by the command of the Constitution, as I said. And therefore, I believe that the Constitution, which is absolutely clear in terms of what falls within the remit of which organ of the state, needs to be adhered to, and its discipline observed by all three organs of the state.
Thank you, sir. And there's another question by Sangeeta Bharti. She wants to know what is why there was a shift in the response of the Supreme Court when it came to migrant labor and later on now on the vaccination policy.
Clearly, I think the Supreme Court sensed the disappointment of the people in its initial response. And as I said, Supreme Court has ensured, as it was duty bound to do, that judicial conscience and national sensitivities were aligned. And please remember, as Justice Cardozo of the United States Supreme Court reminded us, the great tides and currents of history do not leave the judges by in their stride. And the judges, in fairness to them, realized that this was an extraordinary situation where the judiciary must play a proactive role in bringing succor to the people. So, in the process, I believe it has partially restored and redeemed its image as the keeper of national conscience.
So there's another question. Do you think that different benches of the Supreme Court act differently and give the response differently in different situations?
Yes, that has been noticed and that has been seen, and most constitutional scholars have recommended the utility of the court acting en banc, which means together, in deciding certain cases, so that we don't get conflicting decisions by different benches of the high courts. But as long as we have the system where the court is in the exercise of its jurisdiction is broken up into benches, which I think is a practical necessity, some differences in perceptions are bound to be there. Although I must say that the different benches of the court pay respect, as indeed they must, to the decisions of the benches of co-equal jurisdiction. Therefore, there is a natural tendency and desire of the different benches not to be out of step with each other in similar cases on similar issues. But certainly to the extent that there are certain subjective elements of of understanding that go into the process of judicial decision making, there are bound to be some variations in how different judges approach a different subject.
Thank you, sir. Dr. D. Uma Maheshwari, who's a faculty in our university, she has a question, sir. Whether the government, which is using the public health crisis to cover this, public health crisis as cover to seize new powers that have little to do with pandemic, will it ever be relinquished? That is, they're taking new. Yes, sir.
Well, first of all, this itself is a question whether they have arrogated to themselves greater powers than they could within the framework of their remit, and whether once they have assumed that kind of power, they will give that power back. The answer to the second question is given to us by history. Power once assumed is seldom given back from where it comes. But whether in the pandemic, the court has exceeded its jurisdiction, in my personal opinion, is doubtful. Because if Article 21 has to be read in its expansive understanding as expounded by the court in a series of decisions, then whatever the courts are doing, I would say, is within their remit. If the executive were to falter or be remiss in the exercise of its functions, who other than higher judiciary is there to call it to account? And therefore, I think that as those who have been mandated to keep an oversight over the constitutionality of government's decisions, the courts in a pandemic situation have performed exceptionally well and must receive the commendation of the nation.
Thank you, sir. So there's another question. 1 second.
There is one by Parichai Gautam also.
Yes, ma'am, you can read it, ma'am.
From Parichai Gautam, sir, he says, sir, in your opinion, does the judiciary need to play a more active role considering the present situation in the country on health grounds and shattering economy, especially for the protection of Article 21? Sir, the response?
Well, I
Thank
think the judiciary has played a fairly active role, and it is for the judiciary itself to determine as to what the limits of its intervention can be. After all, at the end of the day, it is necessary for the Supreme Court and the higher judiciary to observe the discipline of an institutional restraint, because it is restraint on the part of the judiciary that stabilizes the system of dispersal of power between three organs of the state. Judiciary is more than conscience, as the Supreme Court has repeatedly said. And in fact, even in this particular judgment of Justice Chandrachud, to which I referred to in some detail in my opening remarks, the court has gone out of the way to say that it is undertaking a dialogic process. It is not giving a writ, or it is not imposing its views on the government, but it is trying to flesh out the best possible policy prescriptions in these extraordinary times. So the court is aware of institutional restraints which are inherent in its position as not being the executive arm of the state. It is only thus far that the judiciary can go in focusing on critical national issues. Therefore, the answer to the question is that just as an activist judiciary is sometimes, or is most of the time, necessary in order to hold the government true to its constitutional obligations, it must also accept on its own institutional restraints upon its own power and remit. And these are clearly delineated in the scheme of the Constitution.
I don't know whether this question by Sangeeta Bharti ma'am is asked, Ranjit, regarding Apex Code reacting differently.
Yes, yes. So there's another question from Anjali. Sir, whether the principle of no work, no wage is applicable in the present extraordinary situation?
I think we must wait for the Supreme Court to pronounce upon it. I think most of these, I think the court will, if at all this was a specific issue raised before it, and in some ways it has come before it when the court has given some respite to the employers, but has also secured that the people without work are not rendered entirely destitute by the blocking of all wages to them. So I think some middle ground has to be found as a kind of compromise in an extraordinary situation.
There's a question from Bhuvneshwari, sir, whether there's a need for reducing any kind of restrictions to judicial outreach or judicial overstepping in the present scenario, where we can find some judicial decisions which is creating some problem between the judiciary and the executive.
But I think this is really a function of interinstitutional coordination. At the end of the day, it is in nobody's interest that there is a raging and an ongoing conflict between the executive and the judiciary, because ultimately the executive has to implement the decisions of the judiciary, and the judiciary cannot really expect those decisions to be enforced about which there is a practical impossibility. And the executive or the government can always plead a legal impossibility. And the courts have long recognized that its decisions are entitled to weight only to the extent that they are enforceable and they are seen to be credible. So I think we needn't detain ourselves on this account much longer, for the simple reason that the higher judiciary, the Supreme Court and the high courts, are more than cognizant of the restraints within which they have to give their decisions, as is the executive, which is cognizant of the need to respect judicial intervention where the judiciary in its wisdom so decides to intervene.
Thank you, sir. There's a question from Saksham Gupta, whether the judiciary has to play a vital role in protecting frontline workers, especially nowadays we can see a lot of incidents where doctors, where police officials are getting assaulted, and it becomes viral in the web media also.
Various high courts and the Supreme Court have issued necessary instructions to accord police protection to frontline workers and doctors and medical staff. The Supreme Court has already, the high courts have already assumed jurisdiction in that behalf, and a series of high courts have given instructions. I know Delhi High Court has, I think the Bombay High Court also has. And I must also compliment the Madras High Court in coming down very heavily on the Election Commission of India itself for not ensuring the observance of the COVID-19 medical protocol during the recently held assembly elections. So I think the courts are doing their job. One may ask if the Constitution invests only the Election Commission of India with the final conduct of elections, but that has not stopped the Madras High Court, and in my view, rightly so, from exercising its constitutional jurisdiction under Article 226 to question the Election Commission for its failure or inability to ensure that the lives and health of the people are not at risk for non-observance of the COVID-19 medical protocol during elections.
So there's a question about right to decent burial, role of judiciary on the right to decent burial. And also the second part of the question is about the role of judiciary in capping and preventing hoarding of essential medicines.
Who is this question from?
Yeah, 1 second, sir. Sorry.
Gitanjali Gupta.
Gitanjali Gupta.
Okay, well, I must answer the first question about the right to right to decent burial is a part of the constitutional right to dignity in death under Article 21. I was one of the first people to have raised this issue by way of a letter petition to the then Chief Justice of India, when we saw extremely troubling and distressing visuals on the national television of dead bodies being thrown into pits, and lately dead bodies being thrown into the Ganges, and not even accorded decent burial. This is an extremely important issue. The Supreme Court has seized of the matter. It has adverted to it in its judgments. But even so, the challenge is that the observations and directions of the court and its and the expression of distress on what is happening has not been translated into concrete action. So we have again requested the Honorable Supreme Court to issue the necessary guidelines applicable to the entire country, where the right to decent cremation or burial is ensured. This would also mean ensuring enough space for cremation and burial grounds. It would also involve ensuring that electric crematoria are functional across the country, and it would also ensure that the poorest of the poor and the indigent who don't even have the financial resources for the last rites are not denied their dignity, and that the state administrations, the local and municipal bodies, and the village panchayats would assume responsibility for the last rites and decent burial of the poorest of the poor. This is a request that has again been made to the Honorable Supreme Court, and I'm sure some useful instructions would be forthcoming or should be forthcoming from the judiciary.
And there's a question on no work, no wage, Ranjit.
Yeah, that has been answered by sir.
Then Bismi's asked a question. Bismi.
Yes, ma'am, you can read it. Yeah, you can read it, ma'am.
Sir, Bismi Gopalakrishnan, a faculty of an education institution, she's asking, in this pandemic time, medical professionals and other frontline workers have been attacked in the line of duty. A bunch of petitions have been filed highlighting the need to protect medical professionals and also the need to provide ample protection gear like PPE kits to work on. Sir, your response on this matter?
I've already responded, and I've said that various high courts have already passed suitable instructions and directions to ensure that police protection is given to frontline workers and medical doctors in the pandemic situation. This has already been answered, and the high courts are already seized of the matter, and they have given suitable instructions.
Yes. So there's a question from Advocate Arvind Seth, whether there is an increase in judicial activism as of now in large public interest, and whether this is resulting in the position of the state withering away.
I don't think judicial activism leads to the state withering away. I think judicial activism sustains the state and sustains the fundamental principles of the Constitution. Judicial activism is justified only where it is in aid of the Constitution, and anything in aid of the Constitution is by way of strengthening the edifice of the democratic state. And therefore, I think that Arvind should not read a necessary conflict between judicial activism and the strength of the Indian state. It is the contrary.
Okay. Madam, you wanted to, Kumar, madam?
Can't hear you.
Sorry.
Yeah.
Can you hear me now?
Yeah, I can hear you now.
Yeah.
Oh, yeah. Sorry, I've unmuted now. Srishti Singhal is asking, sir, can't or can we say executive is playing an active role than judiciary in pandemic times?
I don't think the institutions of the Indian state are in competition. I think the judiciary and the executive are playing their respective roles together and in a cooperative enterprise to ensure that the mandate of the Constitution is not ignored in these difficult times, as is the Indian state through its executive. The executive is certainly doing whatever needs to be done, and wherever it is remiss, the Supreme Court and the High Courts are pointing that out. And therefore, it is a collaborative and not an antagonistic exercise innate of the constitutional imperatives.
Most of the questions are answered, and there are some overlapping questions which was not asked. I think we had a wonderful question and answer session.
Yes.
And sir has been very patient in answering, and we can see the wisdom flowing from sir, which is helping the academic fraternity to a greater extent. And from my side, thanks a lot, sir, for answering the questions which has been posted in the chat box. Thank you.
Thank you. Thank you very much for giving me the honor. Thank you.
Now I invite Professor Dr. Harita Devi, Head of the Department of Environmental Law and also Director of Research and Publications, to propose the vote of thanks. Welcome, Dr. Harita.
Thank you, ma'am. Thank you for that opportunity. Hope I am audible. Am I audible?
Yes, yes.
Yes. A warm and cherished morning to one and all present here for the webinar. It's my privilege to propose a vote of thanks and acknowledge the contribution of those who worked hard to make this event. First of all, my thanks to Almighty God for making today's event a grand success. At the outset, we, the Department of Business Law, and all present here, thank our Honorable Vice Chancellor, Professor Dr. N.S. Santosh Kumar, for permitting and encouraging us to do more and more academic activities like this. It is his encouragement that has brought this event also to this high success. On behalf of Tamil Nadu Dr. Ambedkar Law University, I deem it a privilege and an honor to propose the heartfelt thanks to our chief guest, respected ASHWANI Kumar sir, who spent his busiest time gracing the occasion. Today, we had the opportunity to hear your thoughts, and this is definitely encouraging us in our future events, sir. Your thoughts have enlightened our minds and shown us a new path. Thanks for adorning the occasion and sharing your opinions today. And especially, as Ranjit sir has already pointed out, our question answer session. We have never seen a speaker answering the questions so patiently, including mine. So personally and on behalf of all present here, I thank you once again for gracing the occasion. A special mention and thank you to our Director and Registrar in Charge, Professor Balaji sir, for being the catalyst that inspires us to do our best and stand as a pillar of power. I thank our respected Director of Legal Studies, Professor Chokalingam sir, and Professor Gauri Ramesh madam, Principal of Government Law College, Pudupakam, for joining us and gracing this occasion. I need to mention my deep sense of appreciation to all professors, head of the departments, and colleagues who joined us for this event and made it memorable. We have been fortunate to be supported by a team of very active and dedicated students who are well versed in their jobs. I lack words for their participation and their willingness to complete tasks beyond their comfort zones. It is they who brought out the brochure. They did all works, and even today, till today, they are supporting us. With deep sense of appreciation, we thank all our participants all over India who joined us today for sparing their valuable time to join us. Without you, there is no event that is to be success. I also want to thank the people who work behind the scene to execute this event. Our technical arrangement team, Darwin and others, who has seen that all works have been done smoothly. I would like to say that we all are most grateful to all the speakers on this forum today. We thank you, and I also register my special thanks to our head of the department, Professor Kumudaratna ma'am, who has arranged this function in a very smooth way. I thank our colleague and friend, Mr. Ranjit Abraham sir, for having moderated the question answer session and also joined us today. We thank you for being us with this day. It's a great pleasure. I end with a quote: success is not final, failure is not fatal. It is the courage to continue that counts, said Winston S. Churchill. Yes, during this pandemic, let's move on with courage and supporting each other. Follow all the instructions given by the government. Stay home, stay safe. Thank you very much.
I'd like to register my special thanks to Professor Dr. Chokalingam sir. Dear sir, thank you very much for sparing your valuable time and coming to our webinar. Thank you, sir. So we'll move on. Thank you very much. All of us can disperse. Thank you.
And feedback form is there?
Yes, feedback form is there, and it is also in the YouTube.
Okay.
People who are seeing the YouTube, there also we have posted.
Okay, thank you.
Yeah. Okay.
Thank you, ma'am. Thank you for the opportunity.
Thank you, everyone. We may disperse. Thanks a lot.